Good afternoon, everyone. Thank you very much for joining. We're just going to hold tight, wait a few minutes for people to join us before getting started. Safta, Alyssa, how are you doing this afternoon? You keeping cool, just about?
Oh, just about. It's very uncomfortable. Shouldn't complain because it's lovely to have some sunshine, but it is really not what we're used to in this country.
Really not, is it? No.
It's unprecedented, isn't it? As I say, it's nice.
Yeah, it's the British way. If it's hot, we'll complain. If it's cold, we'll complain.
Absolutely. We're British. We complain.
Exactly. Lovely. Right, I think I'm going to get started. So good afternoon, everyone. Thank you for joining and welcome to LAW2022 Online. Family Law Shape the Debate, sponsored by Our Family Wizard with me, James Evans, Safta Mahmood and Alyssa DaCosta-Walden. In this live session, you can put your questions to Alyssa and Safta and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within the next few days, so please do keep an eye out for this. As I said, my name is James Evans. I'm the head of UK professional education at Our Family Wizard, and I've spent 4 years as a teacher before joining the family law community 3.5 years ago. And my role really is to introduce Our Family Wizard to family law practitioners around the country. I work with courts, chambers, CAFCAS, organisations, charities all across the country to help parents with their communication. I'm a member of the East Sussex Resolution Committee, the Family Dispute Solutions Committee with Alyssa here, the Family Law Language Project, and we partner with a number of organisations around the country. I was shortlisted for an Innovation Award in Mediation and for Resolution this year, and my main focus is delivering training on Our Family Wizard to practitioners. Safta has extensive experience in both practicing and teaching family and children law for over 27 years. Safta practices predominantly in children law proceedings alongside his lecturing and legal writing. He has been a continuous member of the Law Society Children Law Accredited Scheme for approximately 20 years and is both an assessor and an author, having written in various legal publications, including for the Law Society. He is a highly articulate and popular speaker who has a practical and pragmatic approach to his subject. As part of LAW2022 Online, Safta sessions include Enforcement of Child Arrangements, Options and Dilemmas 2022, and Private Children Law Update, Fact Findings and Domestic Abuse, Current Trends 2022. Alyssa is a practicing barrister at Newport Chambers in London. She specialises in financial remedy cases and is also an expert in cohabitation claims. She is a regular speaker on legal topics and an author. During her career, Alyssa has contributed to Blackstone Civil Practice, co-authored Family and Matrimonial Law, Cavendish, solely authored Everything You Wanted to Know About Practicing Family Law, Cavendish in 2004, and last year contributed the chapter on Trust Law to Resolution's cohabitation book. Alyssa encourages and practices non-court dispute resolution methods as an experienced mediator, collaborative lawyer, and family law arbitrator in finance. As part of LAW2022 Online, Alyssa's sessions include fact-finding hearings in private children law proceedings 2022 and security for costs and soft loans 2022. So to kick things off, we are going to start with some of the pre-submitted questions that you have been sending through. Now, some of these are directed to Safta or Alyssa, but we've done this many times before, and often these conversations will go off in lots of different tangents with both our participants answering those questions. So hopefully it will be a very fruitful conversation today. The first question is directed to you, Safta, and that question is, what are the various options available to enforce child arrangement orders, specifying spending time with or otherwise have contact with?
Lovely. Well, thank you very much indeed, James, for a lovely introduction for Alyssa and I. Thank you very much indeed, and it's good to be here. So thank you. So this first question, this is, as you can imagine, a classic dilemma that we often come across, which are there's various options available, and some are more perhaps available or going to be more available in many ways in terms of ensuring we get the results. So the idea to say, right, that's it, you've got to comply with the contact regime, and I'm using the word contact loosely, of course, as we know the term nowadays is spending time with otherwise having contact with. I don't think many judges like that. We still use the good old-fashioned contact, don't we?
I don't think many lawyers like it either because it's so clunky.
It is.
Isn't it? Whereas we all know what we're talking about when we say contact.
Exactly. That's right. So one of the options is a so-called, suspended residence order, as we call it. And, the idea that you've got to comply with these orders that we've made provision for. And if you don't, if you fail to comply with these orders, 3 strikes on your out, so to speak, in the sense that if you fail to comply with these orders, then next time around, I'm going to make an order under Section 34 Family Law Act of 86, where I'm actually going to authorise the police to use reasonable force to take children and place with the non-resident parent. Now, that's one option, and that does work sometimes. But like I say, each case has to be looked at on its own facts. Sometimes we're looking at switching living with arrangements altogether. There's a Children and Adoption Act 2006 that brought in these enforcement provisions, enforcement orders, financial compensation. There's the SPIPs, the Separated Parenting Information Programs, the Working Together for Children. Those are some options. Sometimes it's almost re-looking at contact and saying, actually, do we need to reconsider what the terms of the order are? So I think, there are a lot of options out there, but what I would say is...
another one, Safta. I don't think you've mentioned the one that they call it unpaid work.
Unpaid, yeah, that's right.
I mean, it's essentially community service.
Yeah. That's right. So absolutely. So enforcement orders, these unpaid work requirements, which has been around now for 2006, 2008 that came in. I've yet to have a case where actually the court has gone as far as actually imposing it. They've threatened it. They've threatened it a few times. But the reality is, firstly, as you know, even before COVID, the law on that does say that if the court does order it, it cannot conflict with a person's religious, cultural, educational, work commitments. Of course, somebody who wants to escape from having to do this may come up with, those reasons. And then, of course, COVID came in, as you know, and that's exacerbated matters in terms of then limiting the types of cases where it could be ordered anyway. So it's an option, but the reality is it's not one that's really going to be followed through in many cases. Okay, so those are some options.
Yeah, I just want to say there are cases, and unfortunately I have dealt with 2 very recently, where there has been a serious threat to transfer residence. Okay. And although it was a very serious threat, what the judge was looking at, and I think we have to not just look at the remedies with enforcement, but look at the practicalities. And it's always going to, where there is a sort of serious remedy sought, like a change of residence, I think we have to remember that the court is also going to look at the ages of the children concerned, because a change of residence is a really draconian and drastic measure to take. And I have seen suggestions that sound awful, where the expert psychologist, psychiatrist, whatever, has said, well, in order to achieve this, if that's what the court wants to do, these children have to be taken away from one parent, put in some sort of metaphorical holding position, yes, usually local authority, before being moved to the other parent. So, that is, although it's often threatened, and occasionally it's done, very, very infrequently, that's a really serious and draconian thing to do.
Absolutely. And that just really echoes one of the cases some of you will know some years ago, the Ries case, where exactly that happened with father. Well, you've almost got to do a kind of cold turkey approach, which is you've got to move him now. The longer you leave it, the more entrenched he's going to get.
But that's also damaging.
Exactly. Whereas the other expert was saying, actually do a kind of stepping stone process. And that's where, as you say, Alyssa, they placed him in foster care. He almost felt that he was being punished for speaking.
Yes, he did. He absolutely did. And when you read the case, it sounds like he was being punished for the other parent's alienation. And, it's a really, it's so difficult, because the courts, they can recognize that parental alienation has taken place and want to deal with it. But the person who should be punished is the one who's doing the alienation.
That's right.
And very often it's not conscious. And that parent has their own psychological problems. So you have to question the morality and the efficacy of punishing that parent. And also you've got to balance why should the child feel like they're being punished?
Exactly.
Did the out of interest, did the court actually use the phrasing parental alienation?
Yeah.
I know the courts are not necessarily too keen on that phrasing.
Oh, they do use it.
They do use it. They do, yeah, they do use it. What, however, has happened, the more kind of recent kind of thinking is last year, back in October, the President of Family Divisions, Andrew McFarlane, he was making very clear that we're overusing experts, you know, and I think they're clawing back on that. And that's where there is currently a thinking that actually we've got to claw back on a number of experts we are relying upon to give us an opinion on whether this is parental alienation or not. So it's very difficult. I've found that actually when we're lodging our Part 25s, it's not easy getting permission to actually instruct an expert, whoever that may be, to give us an opinion on parental alienation. So, but at the
end of the day, it is after all only an opinion.
Exactly. That's right.
Interesting. No, that's very helpful. Thank you. And then for those who are listening, if you do want to ask questions to Alyssa and Safta, please just use the chat function on the right. We are happy to provide them as we go. But the next question that's been pre-submitted is for you, Alyssa. And that question is, when would it be appropriate to apply for security for costs in family proceedings?
Well, at the moment, I would say there aren't very many appropriate situations to do it. It's a remedy that's often used in civil cases where one is defending, and there's a reason to worry that if you're the defendant and you think you've got a good prospect of succeeding, that you're going to have difficulties in recouping your costs if you get a cost order. And of course, this is the crux, because in the civil regime, costs follow the event. The winner gets their costs paid by the loser. The difference in family, and that's probably why our one decision, our one reported case on security for cost in family, and there is only one, it's taken like 10 years. It's the first one since the inception of the new family procedurals, is because we have a completely different cost regime. There's a sort of presumption in favour of no order as to costs, and it's very rare, although I have to say, it's a lot rarer to get cost orders in children proceedings. Much more, having said that, I got one on Monday. I did. It's much more common and becoming more frequent and less rare to get cost orders for litigation misconduct and general financial misconduct in financial cases. But going back to the original question, where you are likely, and you've got to consider that either the financial remedy case is so serious in its litigation misconduct or financial misconduct that a cost order is likely. And then you've got to look at the issue. So if a cost order is likely, am I going to have difficulty enforcing it? And if the answer to that is yes, because, for example, the person against whom you'd want to enforce it is out of the jurisdiction, then you would, that's the reason to seek security for costs.
Listen, that's really, really useful. And if just taking that kind of further on, knowing family, we're going to have Talata claims, of course, even though I appreciate the procedure is, purely civil CPR. Is that, somewhere where we may consider maybe going for security costs? If I was for a defendant and, I'm thinking to myself, well, I think I've got a decent defence here.
Well, a Talata claim is certainly in the civil jurisdiction, not the family jurisdiction. So in a Talata claim, costs would follow the event. So in a claim like that, if, for example, you were concerned about having to enforce because one of the parties, the other party was out of the jurisdiction, or for some other reason that they'd been a bit, they hadn't been terribly forthcoming about their home address or stuff like that, where you thought there was, they were being disingenuous about themselves procedurally, then you'd have to check whether you met one of the gateway criteria to make that application. I should say, I don't know if any of you have been reading a case about the purple suitcase.
I haven't heard of it, no.
Oh, when it was in the mail and it hit the eye yesterday.
Sure.
That's my case. Okay. And that's a civil case, as well as a suitcase. The long story that bears little relation to that which has been reported in the press. However, that was a case where we'd made a security for cost application because the claimant is outside the jurisdiction and lives in America. Unfortunately, and this is another point that practitioners need to be aware of, I came on the scene late, direct access case. The case had been started by solicitors who had their security for cost application included the entire costs of the case. That's wrong. What you're looking at often in a security for cost application is simply getting the costs of enforcement because it's going to be more expensive and difficult to enforce in a different jurisdiction. So practitioners would be well advised to think very carefully and focus on what it is they're trying to achieve in an application for security for costs. You know, going for the whole lot, you're not going to succeed.
Not going to succeed, yeah. That's really helpful. Thank you.
Really, really helpful. Thank you, Alyssa. Next question for you, Safta. What are the aspects of the revised Part 37 FPR 2010 in terms of committal?
Okay, so yes, so this is Part 37, and this is the provision that relates to seeking then, as it says, committal for breaches of orders, breaches of undertakings in family proceedings. And this was updated back in October, 1st of October 2020. It was updated. It's more streamlined and it's more akin to what we have now with the CPR. And I suppose for us, you know, as family practitioners, the things to bear in mind are, first and foremost, there's a new form, and we all like forms, don't we? So there's a new form that came in. There's a form for everything, isn't there? And the one that came in last July, end of July, it's called an FC 600. And it's a really nice form, actually, FC 600. I like it. It is about 10 pages long, but then...
What do you like about it?
Well, firstly, it's laid out in such a way that it covers all the elements of Part 37 nicely laid out in terms of, right, this is the first bit, 37.1, 37.2. So what it does, it avoids you having to do a very detailed affidavit and support work. Because as you know, Alyssa and James, you know, we've had cases, haven't we, where whenever you've gone for committal, and if you're on the receiving end, you're for the respondent or the defendant, first thing we're going to look for is it defective? Did they numerically set out each of the times that the person failed to comply with the order? Have they numerically set it out, given us dates, times, events? Have they personally served, or were they allowed to dispense with personal service? Did they inform the respondent or the defendant that they have the right to take independent legal advice, they have the right to apply for criminal legal aid? So these are all the kind of things, if you're for a defendant or respondent, you're going to look for, aren't you, to kind of throw out that committal application.
Well, the reason you're going to look for those things, and the reason that all those things are essential, is because the ultimate punishment is a loss of liberty.
Absolutely.
And that's what makes it so crucial to get it right.
That's right. That's right. And that's why with these revised provisions that came in, and hence, like I say, the new form that's come in, it has made it easier, I'd suggest, for us as family lawyers, so that it's less likely we're going to get it wrong, you know, as long as we follow the format, we follow. I mean, that case of Hart and Hart a few years ago, the one where the bloke, if I remember, I think he decided to burn some of the VAT documents as well to stop his wife from getting her hands on that. I think he was in his 70s or something, and the judge decided to impose a 17-month prison sentence against him for contempt. So, you know, they will order it if needs be.
Oh, Scott Young.
Yeah.
I can't remember where the 400 million went.
Exactly.
Prison.
And sadly, he had a very sad ending, didn't he?
He did. Let's not go there. It's not very nice.
That's right. So yeah, so that's the kind of committal position as it stands at the moment.
Sure. No, that's extremely helpful, Safta. Thank you. Moving on to our next pre-submitted question. Alyssa, what is the test for the court considering an application?
Which application?
For any application, I suppose.
Well, no. I mean, there's different tests for different applications. We're talking security for costs.
I think we're still on security for costs. Okay. Yeah. I mean, so I mean, the follow-up question, which I think you already answered, which is, you know, why are those cost applications made? I think we covered that. Yeah. So the follow-up is, what's the test for court considering those cost applications? Yeah.
Okay. So the sort of test is, it's governed by the family procedure rules, two tiny little rules, 20.6 and 20.7, which I'm just looking at on my other screen. So really what you're looking at, it's whether the conditions are satisfied, and it's all sorts of conditions, and it's one or more of the conditions are satisfied, which is residence out of the jurisdiction. That is the most, I would say, usual reason that has to be passed, or the applicant's changed address since the application. And when we're talking about the application, we're actually talking about usually the claimant or the applicant in the wider application, not the applicant for the security for cost application. So it gets so confusing. Or he's failed to give an address in the application form, or he's given an incorrect address, or he's taken steps in relation to his assets that would make it difficult to enforce an order for costs. So really, the test is, does this person live outside the jurisdiction, or have they been a bit naughty? Yeah, and if they're a bit naughty, that is that's the gateway. That's the gateway to get in to make that application. And then really it's a question of how the court exercises its discretion. But that is another question. So I won't go into that.
No, that's very helpful. Thank you. Safta, what is the purpose of an appointment of a child's guardian and joinder under Rule 16.4?
Right, okay, so yes, so 16.4 of the FPR, Family Procedure Rules, this is where we're looking at children being joined as parties. As you'll be aware that in private children or cases, generally the child will not be a party, hence they won't have a representative representing them purely in their own capacity. So they won't have a solicitor, normally they won't have a lawyer, they won't have a guardian. But sometimes 16.4 requires that. And as Liz and I have mentioned, some of the parental alienation cases, some of those, but not always, will require that. One thing to watch though with those types of parental alienation cases, and 16.4 as the senior judiciary have mentioned, is timing. If you leave it too late and there's plentiful evidence that this child has been alienated and they're entrenched in their views, well, if you get them joined and then suddenly you get them seen by, say, guardian and or lawyer, what they're going to be saying, is that actually their view, or is it them just simply expressing the views of the parent who is priming them, coaching them? And therefore, timing, I would suggest, is very, very important when it comes to a 16.4 appointment. I'm a firm believer of 16.4 because what it does do is it allows just that, allows a child to have a voice in a different way. They, like say, have that representation through guardian and or lawyer, and at least they then feel part and parcel of that process. So whatever decision is made, at least they can feel, well, at least my views were taken into account. I accept the judge maybe hasn't gone with what I wanted, but it helps them to kind of move on in that regard. And cases of parental alienation, cases where contact has ceased, or it's been where you've got intractable, implacable kind of hostility cases, maybe an older child opposing a cause of action. The COVID vaccination classic example, if you've got a private law case where mum says, I think the child should have a COVID jab, dad says no, child's competent, child's Gillick competent, that's where we may get 16.4s in those kind of cases. Some of the removal cases, as Alyssa has mentioned, removal from a jurisdiction.
Yeah, really important, I think, for children. And as we know, their voice is louder, if you like, the older they are.
Yeah.
But I think really important for children who are articulate enough and intelligent and sensible enough to use their voice, to know that also they've been listened to, even if, as you say, they don't get what they want or exactly what they want, but at least they feel they've been able to express themselves and somebody's taken it on board.
Yeah, absolutely.
Really important.
Absolutely, really important.
That's great. Thank you both. We've had a live question come through, and thank you for that person. There are. Please do continue to send through live questions as we go. And the question is this: do you find that more recently guardians are less likely to be appointed, not due to timing, but instead due to CAFCAS or other local authorities not having the budget or resources? In this instance, what would you suggest is done as an alternative?
Sure. Okay. Should I go with that one first? Okay, well, that's a good question. Thank you very much indeed. We like those questions, don't we? Okay.
We do.
So I suppose what I would say on that is, yes, timing, is obviously important, but also, resources is, and sadly has continued to be a feature. And I wouldn't be out of line in saying that now that we're coming out of COVID slowly but surely, and although the infection rates are going up again, the courts are still trying to grapple with this, aren't they? And as you know, the president has said, each hearing has to, we're going to make it count. But as I'm sure Alyssa and James, you'll know that when it comes to the Section 7 reports that are being done in private law, historically, we used to get these done in about 12 weeks. But it's not uncommon to get these done nowadays where you're looking at maybe close to 20 weeks, even longer than that in some cases.
And I've had cases where, you think you've got your hearing coming up, and then you get a letter from CAFCAS to say, terribly sorry, pressure of work, we will not be able to do this in time. And then you've got to shift your hearing.
Yeah.
And of course, once you do that, whatever the recommendations, that status quo is getting more of a status quo because it's getting longer simply because of the pressure on CAFCAS and other resources.
That's right. And, it is tough. And, seeing it from that side, from the position of the local authority in CAFCAS, it is hard. And, having that represented and dealt with it from that side, it's not easy. So I suppose going back to the question, which is in this instance, what would I suggest? Well, I would say this as an alternative. I think the other option, which is there and has been there for a long time, since April 2010, is about the judge meeting the child. It's an opportunity, again, for the child, as Alyssa was saying, to feel part and parcel of the process. The judge meeting with the child, they can see the child even as young as 7 if they feel the child is sufficiently able and competent to be able to express their views. And I would say that's an option, and we should take that opportunity if it's available. It's not for the purpose of replicating what CAFCAS or social workers do, but it's to enable the judge, or rather the child, to feel that they are part and parcel of the process. And it works.
Yeah, I'm just trying to think a bit creatively as well, if there's any other option. And I'm just thinking, I've had cases where we've actually got an independent social worker involved. They've often got that CAFCAS background.
Yes.
One in particular. And, provided both parties agree and the court's prepared to sanction it, if the parties agree to pay and share the cost, if you can't get CAFCAS in time and it is a particular matter of more urgency that you can't wait for CAFCAS because their delay is just too great and there's reasons not to wait for that, maybe get the parties to share in the cost of an ISW.
Yeah, absolutely. That's isn't there? And also there's, for example, the Pathfinder program that's been used of areas around, and getting almost just a kind of wishes and feelings report, and rather than an entire Section 7, just get.
Yeah, exactly. Again, you've got to tailor it for the particular case, haven't you?
Of course. And from my perspective, whilst our family wizard isn't an alternative, it can really help in those situations, facilitating that communication between those parties. Particularly as we've given, CAFCAS have had the training on our family wizard, they should all know about it, as have a lot of independent social workers. So we are happy to, not resolve that issue, but be helpful in facilitating between the child and those parties where suitable, safely and appropriately. No, that's really helpful. And the person who asked this question has come back and said that is really helpful. Thank you very much. And they were also considering an ISW, so that's really, really useful. So thank you. Coming back to you, Alyssa, and relating back to the cost questions, more specifically about loans. There's a couple of questions about loans. Yeah. So the first one is, what's the difference between a hard and soft loan, and is there any uniformity for decisions on loans?
Okay. Well, up until I can answer the second one more quickly than the first.
Sure.
The second question, is there any uniformity of decision making?
Yeah.
Well, for those of you tuning in that have already seen the PowerPoint presentation, I took everybody through a bit of a whistle-stop tour of the previous case law prior to His Honour Judge Hess's decision in P&Q. And you can see there is absolutely no uniformity at all, no rhyme or reason where the same set of circumstances will result in a completely different decision depending on who's hearing the case. So uniformity, P&Q seeks to resolve this question. But what's the difference between a hard and soft loan? And I think we've all had cases where the client says, I owe my mum, dad, second cousin 6 times removed, thousands of pounds. They've helped me with my legal costs. and they've got a sort of loan agreement that they found on Google, and they've got everybody to fill in and sign. Simply because there is something purporting to be a loan agreement that has been signed by all parties doesn't turn what is essentially a soft loan into a hard loan. There may be circumstances where a court is prepared to accept, for example, where a family member is paying legal costs for a party directly to their solicitors. That, I would say, is a hard loan. If it's expected that will be repaid out of settlement monies. But essentially, the major difference is a hard loan is something that has a commercial aura about it. It's from a bank, a building society, a credit company, hire purchase agreement, lease agreements, something that is with a commercial entity in writing. And if the loan is not repaid or in any way there is a breach of the terms and conditions of the loan, the entity who has provided the money will take legal action or is capable of taking legal action. That is what a hard loan is. Whereas a soft loan, the courts regard soft loans as generally from friends and family who will not seek to enforce it. You know, much as they would like the money back, and it is given not as a gift, but it's lent, they're not going to take the same kind of action or any action to enforce it.
Brilliant. That's so helpful. Thank you. Safta, coming back to you, I'm looking through the questions, and there's a lot of things that we've sort of gently touched on, you know, that we've already kind of covered. And one of those questions is, what's your view as to the guardians to encourage judges to meet with children involved with proceedings? And we did touch on that previously. So perhaps we can link that in with the other questions that are similar to this, along the lines of what does it mean to make a child available for contact, and in what situations may a court remove the PR from a father? If you don't mind me sort of joining questions.
Yeah, sure. Yeah, no problem at all. So I suppose the first part in terms of judge meeting the child. So we've looked at that, and there is that really useful guidance, like say April 2010, well worth looking at, and it makes it very clear. It's really set out quite well in terms of the benefits of that in private and public children law. In terms of making a child available, there's been a lot of debate on this. I mean, there's some of the older case law, LW, which said to make available is just that. To make available is not to necessarily encourage, not to ensure, not to even make necessarily other sanctions. You've got to make it happen. So if that means you need to induce the child, if you need to sanction, if you need to, for example, blandish, if you need to, short of brute force, as you know, we're not allowed to hit the children, of course, but if we need to take other options, which cumulatively, collectively, are going to try and make this contact happen, expected of a parent. And you would have seen that, in fact, interestingly, when we look at the standard orders that we use, which have been handed down over the last 3-4 years, you'll notice on there, on the menu of the orders, one of theirs, it specifically says when it comes to contact, is the child in whose care the child is shall ensure. So it specifically uses the word shall ensure to put that emphasis on it, as opposed to merely make available. Because as you can imagine, it's too easy, isn't it, for a parent who's going to play the system, shall I say. They might say, well, I told my daughter that, look, you're coming to see her on Saturday, but she shrugged her shoulders and said, you know what, Mum, I can't be bothered. Well, that's not good enough. The mother's got to try more than that. There are things you can do, and I wouldn't suggest you necessarily go down these routes unless you feel you need to. I mean, there's recitals in the orders. You can use section 11.7. You can put conditions attached to the contact provision if you need to be. Each case will sit on its own circumstances. So there's that. And I think, James, you mentioned the other bit about removing PR. I mean, there's been a number of cases on that. There was one D&E last year, horrific case where you got a chap who's serving time in prison. He's not a very good man at all. And the mother applied for him to lose his PR. It's not an easy application to make, but if you can make out the fact that by him retaining his PR, which in that case he was serving time in prison, the mother, if she wanted to take the child away, let's say just for a week and somewhere hot, although they probably don't need to do that at the moment, do they?
No.
You know, but if they wanted to go, say, Spain for a week, let's say, and he's got PR, well, she needs his consent. Otherwise, you know, she's committing an offence.
Yeah, and there he is sitting in prison.
Exactly, saying, I'm not going to
take the child away.
Yeah.
But if he wants to be difficult and bloody minded.
Yeah, exactly. So that's where they removed the PR from him, because by him retaining it, it's going to affect the mother's ability to continue to provide that day-to-day care of the child. So
and that will affect, of course, what's in the child's best interest.
Of course.
That's right.
No, that's really interesting. Thank you. And you mentioned a Section 11.7 order. That's one that I see very regularly. Our Family Wizards draft order is a Section 11.7. But I don't know, Safta, I know you're a fan of it, but is it one that's reasonably common or one that's underutilised, would you say?
It's not common, and I think that's probably because lawyers are perhaps either unaware of it or they don't use it as often as they should. But actually, it's really useful, and I've used it in other ways where, for example, say, I don't know, you got dad who's in a new relationship. Mum's open to the idea of him seeing the children, because after all, it's for him, isn't it? But he's got a new partner. Mum's thinking, given his history, I'm not convinced if this is going to last very long. So she may put 11.7 there to say, actually, a contact's just for him. I don't want his new partner there for the first few sessions. So, you know, that's one of many situations you may want to use it.
Yeah, I agree. I think it is underused. And I think there's lots of situations where we could use it.
Oh, that's I mean, let's say you had Our Family Wizard in the case on Friday. Do you use a Section 11.7 or was that agreed in another way?
We used it in terms of OFW being the activity direction. We used that. I tell you something though, I saw in another case, and I've lifted to put in this order, was, let me just get it up on the screen because in fact I was doing it earlier today. Bear with me everyone, because I think this is really useful. And I saw it in another order and I've not done it before, but I believe in what I call the case principle. And the case principle is copy and steal everything.
Absolutely.
And
nothing's original. You're okay.
Yeah, and I saw this in another order in a different case, and I thought this is brilliant, because in this particular case that I was dealing with, there were, and that's why we needed Our Family Wizard, severe communication issues. And it's really interesting. The court, and here's something, a little hint for practitioners. Barnet, on the floor where the magistrates are, in the waiting area, there's a table and 4 chairs. And we were due to be heard at 10:30. Of course, as usual, another matter gets shoved in the list. Father's in person. I'm representing Mum on direct access. Kafkas is there. And I said, there's a table over there. Why don't we all sit round, the 2 parties, me, Kafkas, and let's see if we can narrow the issues. And the magistrates were delighted because we got in 2 hours later than we should have done. But we'd done a lot of the hard work.
Oh, amazing.
And that really helped. But I saw this in another order, which was, and it helps with expectations, and it's a recital upon the court requiring the parties to adhere to the following schedule of expectations. And here they are. Neither shall denigrate the other in the presence or hearing of the child. There's a bit more to that. Both shall ensure the child is not exposed to further conflict between them. Each party shall ensure the child has a positive picture of the other. Each shall keep the other updated in respect of their email address, telephone number, and address. Both parents agree to be flexible with the other when accommodating requests to spend time with the child on special events and occasions. Now, I think that as a sort of raft of recitals that constitute a schedule of expectations, I would say that those are the expectations that all parents have of each other.
Yeah, of course.
But when they have communication difficulties, they can't deal with that. They just can't make that work. But if it's there in a court order as recitals that you can kind of refer to if you're having that conversation and it gets difficult, I think that can go a long way.
Absolutely.
There was another one that I didn't need because I've got Our Family Wizard. Yeah, that was really helpful. So
that's great. No, and you know what? That language isn't a million miles away from the kind of things I see quite regularly, whether it's in a recital or a condition order, where they get specific to the needs of the communication of that family. And actually, if anyone listening does want to see those, we have copies of those types of orders where they get very specific to the tailored needs of that family, whether that be about the levels of communication or whether that be more administrative, or. I was a teacher. I've seen when school reports, why have you sent it to parent A?
Oh my goodness, yeah, exactly.
Having that in the agreement actually can, you're almost preempting that argument.
Well, that's right.
Or it becomes a problem and therefore affects the child, which is what we stop.
And in a way, it's also recognising where there have been problems and saying, this is how we can move forward with this. I mean, if anybody who's listening, watching, whatever, wants that little schedule of expectations, I'm more than happy to disseminate.
Please do.
Maybe the solicitors group can sort of organise that.
Absolutely. I'm sure if you email the solicitors group, they can send that to you. And on the Our Family Wizard page on the solicitors group, it's a page you can find a copy of our Section 11.7 draft order. So that would be there for you to see as well. But we've had a handful of people messaging already on the chat saying they would be very interested to see that, Alyssa. So
okay, it will be done as soon as we get off.
Absolutely, we'll make sure.
I'll copy it and paste it into an email, and then the solicitors group can do with it as they choose.
Absolutely.
I really do think it's helpful.
Definitely. No, I agree. At the end of this session, about 15 minutes or so, I'm just going to let everyone know where they can access all this information on the solicitors group website and who to access if you do want any follow-up information. So that's where it will be, and we will have that across to you. And that's really helpful. So thank you, both of you.
No, it's good to share these things, I think.
Of course.
Thank you.
Right, going back to these pre-submitted questions, there's a couple more about loans, Alyssa. You want them, or do you want to try something else?
No, I'm happy to talk about loans.
Perfect. Again, I'll try and group these to make it a bit easier for you. So, does it make a difference if the funds provided to a party in financial remedy proceedings are described as a loan? And does it make a difference if the so-called loan is documented in a loan agreement?
Yeah, well, I think I dealt with that one earlier.
Yes, sure. Yeah.
And the first one, as we all know as lawyers, it's not what we call it. It's not what the parties call it. It's what the court's going to call it. How's the court going to regard it? So, someone, and we know this when we're dealing with slaughter claims, when someone says, I put money into the property. Was it a gift? Was it a loan? And also very important in financial remedies. The court will, and we as practitioners should read P&Q very carefully to help advise as to whether something's likely to be considered a gift or a loan. But what the parties call it really is irrelevant. It's how was it given? In what way was it given? Was anything done in writing? If there is a strict loan agreement between a parent and a child, and there might be, the court will look at that and take a view. But there is a difference. Let's not get confused. The court may regard something as a loan, but it may say, nonetheless, it is a soft loan. Yes. And in terms of looking at it in the context of a financial remedy case, we'll say, don't need to consider it as an obligation that has to be repaid. For example, before someone, that's going to have an effect on someone's mortgage capacity. Because the mortgage lender's really going to look at the hard loans, the hard debt that someone has as affecting mortgage capacity, not necessarily the soft debt, because it's soft debt. So something might, depending on...
A lot of hoops to jump through before making that decision.
Indeed, yeah. Exactly. Yeah.
No, that's very helpful. Thank you.
Very helpful, thank you.
Safta, you mentioned COVID earlier. One of the questions is in regards to that. So what is the current judicial position surrounding disputes between parents over whether their child should or should not have the COVID vaccine?
Okay, so this is in relation to a potentially specific issue application on that. And there's in private law, there was one case back in December 2020 on this. So in fact, 15th of December, so about 2 weeks after the first vaccine became available. And in that case, even though it was dad who applied for the MMR jab for his 2 children, if I recall, there was a specific issue application. Mother opposed. She relied on a lot of research in the US trying to argue that there was a link to autism. The judge, quite rightly, I think, based on a case law that we've had and also medical opinion at that stage, said, look, I'm going to order the specific issue application. But then the parents said, look, this vaccine's only recently become available against COVID-19 for adults. If in the future there's one that may be available for children and maybe travel may be permitted for them, would you endorse it? And what the judge at that stage was saying, he said, well, actually, if there is such a vaccine, in the absence of any peer-reviewed research or any medical evidence to show that there is a significant risk of harm to that child if they were to have it, it'd be wrong for me as a judge to say, well, no, I'm not going to endorse this. Now, that was no bitter comment, to be fair, and it was, I think, quite a strong opinion given just, so soon after the first vaccine became available. There were a couple of cases last year. Those are more kind of care case based. There was one back in November last year. There's a case called VC. But the current thinking is, because the winter flu vaccination is now in the routine set of vaccinations for children between 12 to 15, as is COVID for children between 12 to 15 anyway, and that's the medical opinion from the chief medical officer's view, as it states at the moment. And I know politics is in a bit of a disarray at the moment, isn't it? But
understatement of the year.
Yes, that's one way of putting it, yeah.
But the current medical stance is that these are recommended for children between 12 and 15. Then if there was a specific issue application on that, there's a very good chance for that particular child, as long as it's in his or her welfare best interest, the judge will direct it.
Yeah,
that's the current position.
Excellent. No, that's really good. Thank you. Next question from the pre-submitted ones. We've got about, just for reference, we've got about 10 minutes left or so.
Oh, wow, it goes so quickly.
So if anyone does have any more questions to ask Alyssa and Safta, please do drop them in that question box. We'll get them to you. But the next one, Alyssa, is in regards to the mediation voucher scheme. How does that operate? Now, I know it's been extended, I think, until March of 2023. Yeah. We do have another year. Which is excellent news. So, a little bit about how that
make it available to people that otherwise would not have the money to participate. I think that's so important. So important. I know Joe O'Sullivan very well, who's just written the Almost Anything But the Family Court book. And in that book, she references how helpful the mediation voucher scheme has been in terms of families who were going to go to court, who otherwise wouldn't have considered mediation, who ended up mediating because of the voucher. And succeeded.
And the percentage is very high. I don't know off the top of my head, it's over 70% of those families ended up not going to court. Yeah. So it does work, and I think there should be more of this type of encouragement.
Can I just say, I would encourage everyone to go and read the Purple Suitcase case.
Absolutely.
Because I have to say, my clients, we've been trying to settle it for 8 months, since September last year.
Wow.
The claimants refused. But it just demonstrates the importance of leaving the court out. Those of you that have looked at what I've done on my fact-finding stuff, you'll see that there's a quote from an old case where Baroness Hale, I think, cites it in a case where it's clear that as far as evidence is concerned, courts in civil cases, it's balance of probabilities. The best evidence in any case is documentary evidence. The next best evidence is witness evidence. And if something is not in those items, or if the court finds on a balance of probability something didn't happen, then whatever the truth, it didn't happen.
Sure. And
unfortunately, very often, when you get to court, you are leaving the dispute. You are abdicating responsibility. Both reasons. We can't do it. You decide. A complete stranger who will make findings on things that maybe both parties know that's not true, but the court's made a finding. If the court makes a finding, that's the truth of the matter. I hate to say this as a lawyer. You don't go to court if you want to search for truth or justice, I'm afraid. And for parties, the best justice is sort it out yourselves with the assistance of an independent third party, such as a mediator.
Yeah, absolutely. And with that, Alyssa, and I know with some of the stuff we're looking at for this session, they've said it again in this recent K&K case about fact finding.
Yeah, exactly. Yeah.
Because in that case, one of the first things that the president was saying is the judge sadly decided to list it for finding a fact hearing, even though it hadn't been sought. And again, there was the underuse of the family mediation scheme. This is one where mother wasn't teaching.
I don't mind. I mean, we've both covered it. I don't mind.
Yeah, sure. Yeah, I mean, just briefly, K&K is an excellent case, and it's really, really good. Because I must admit, some of these judgments, you do read them and you think, how much further am I with this, and how can I use this going forward in advising clients? But I'd say K&K and HN, the other big,
both of them really read together. Read both of them together.
And really, what K&K I think has done is it's really reconfirmed what I think we've all been saying for years as lawyers, which is, what, we are overusing finding of fact hearings. Somebody says the words domestic abuse, and suddenly we all panic and say,
yeah, exactly. And that isn't to belittle it in any way, but particularly when we're dealing with children cases, you've got to look at it in context. And I think that's, you've got to look at, the question really is, how is a fact-finding hearing going to help? And the question is really, is there such abuse that, or the allegation of abuse, how is that, if proven, going to impact on the well-being of the child and the parent with care? Those are the issues. But also to look at, as we used to, and things like, what kind of abuse we're looking at. Is it a one-off, or are we looking at patterns of behaviour? And the emphasis is very much these days on patterns of behaviour, which I think is important. But was it a one-off? Is it historical? Has it stopped? When was the last incident? Because if we're talking about stuff that's happened like 6 years ago, or happened when the parties were living together, but they've been separated for 3 years and there has not been a single incident since, is the fact-finding going to take it any further? Is it going to help the court? No.
That's right. And on top of that, in Practice Direction 12J, it's an excellent practice direction. Paragraph 18, they're just laid out brilliantly, don't they? And I think K&K, coupled with that guidance that the President handed down on the 5th of May for courts and lay justices, it pulls together really what we should be doing in these cases. Brilliant. Really.
No, that's super. Thank you. Can one of you ping K&K to solicitors group so they can add it to the resource page, please? If
as a case?
As a case, if it's available.
Okay.
Yeah.
Let me make note of that as well.
Thank you. Well, the other question, Alyssa, and this is probably the last one we've got today. People have been looking for the purple suitcase case online but can't find it. Is there a formal name?
It's in. There's a link.
Is it we search purple suitcase into Google?
Yeah, I think if you put purple suitcase into Google, the Mail Online will come up, or you can search the Mail Online. It was on a Microsoft feed yesterday as having been cited in the Eye yesterday, and it was in the Times, I think, last week or the week before. So you can Google the Times.
Yes, thank you. Yes, there's been an enormous amount of interest in that. Most people attending live have asked for that. So
okay, shall we? Would it also help if I pinged across a copy of H&N?
Yes, please.
HN, yeah. So we'll do those two cases. The purple suitcase, but thank you whoever found that, and the schedule of expectations. So you've given me some homework, everyone. Thank you.
Amazing. And that sums us up perfectly, brings us to the end, which, as always with these, we could go on chatting for hours and hours, and there's plenty of questions we haven't got to. So if we didn't get to your question, apologies, but just ping the script and we can get to that when we can. And thank you, Alyssa and Safta, as always. Absolute pleasure. I'm sure I'll see you both very soon.
Yeah, lovely to see you both today.
And thank you to everyone for joining today for the Law 2022 Online Family Law Shape the Debate, hosted by our family wizard. Don't forget to join the solicitors group Law 2022 Online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. There is still time to watch the pre-recorded content, and the expiry date will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this session, if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue worth £35 plus VAT. You can also visit our Family Wizard exhibits page for more information about our programme, and you can message me. My email address is jevans@familywizard.co.uk if there is any more information you'd like to help. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will then receive